Here at McGill University for the 2014 CETA Conference with Professor Martha O'Brien from the University of Victoria, who's an expert in EU and tax law. Professor O'Brien, in what ways do free trade and investment agreements such as the CETA relate to tax law?
Well, there's actually two answers to that question, and it depends on whether you're talking about indirect taxes or direct taxes. Generally, indirect taxes such as import duties, value-added taxes like the GST, sales taxes are a critical part of trade agreements, i.e. free trade in goods and reductions in these kinds of taxes and elimination of discrimination in these kinds of taxes. For direct taxation, this is corporate profits tax, income tax primarily. It's not so much about free trade in goods, but more about restrictions on provisions or the provision of services in the host country and investment from the EU into Canada and vice versa. And so for direct taxes, generally these are governed not by an agreement like the CETA, but they're carved out and dealt with in bilateral tax agreements between each of the CETA or the EU member states, so 28 member states, and there are 28 individual bilateral tax agreements between Canada and each of the EU member states. And that's where direct taxation is primarily dealt with.
Can direct taxation have a negative effect on investment between the EU and Canada?
Yes, definitely it can. Sovereign countries guard their tax jurisdiction very jealously. That's how they raise revenue in order to provide goods and services to their electorate. And so, of course, there's a political element as well. And they don't really want to bind future governments and themselves as to what taxes they can impose. So they do have some almost every country has some discriminatory rules or some rules that could result in double taxation and therefore inhibit cross-border or between two countries investment or trade in services. And so from that perspective, you can have situations where taxation is actually higher if you cross a border than if you stay within your home country. And obviously if the taxes are higher, it's not going to be competitive.
Are there any protections in the CETA for investments from taxation?
There are two that remain that could occur despite the broad tax carve-out and the allocation of tax questions to the bilateral tax treaties. And these are in the case of expropriation using tax measures, or in the case where a country might not accord fair and equitable treatment to an investor from the other jurisdiction. If tax measures are used to deny fair and equitable treatment or to effectively expropriate an investment, those two areas are still left in and can be resolved under the CETA.
What will you be presenting on today here at the conference?
Well, basically you've had just a summary of what I plan to talk about this afternoon, mostly the tax carve-out, the potential for bringing in the investor-state dispute resolution process, and how tax treaties really now govern the direct tax relationship. My other panel members will be dealing with other issues related to tax in this afternoon's session.
Could you perhaps provide an example of the tax carve-out in practice?
That's kind of hard to do because we haven't seen it yet, but there is a question about what is a tax measure. And once you're into a tax measure, then the question is, has it been carved out? And because the carve-out is so broad, it basically says anything that a party to the agreement, or even one of the Canadian provinces, already has in place can stay. So that what we have is a grandfathering or standstill clause. And then we also say that if it's covered by a tax convention, it's not covered by the CETA. So there aren't going to be that many situations, it seems to me, where you could possibly have the CETA apply to a direct tax measure. Now, the two that I mentioned before, fair and equitable treatment and expropriation, we've recently seen the largest ever investor-state dispute resolution ruling in the UCOS against Russia claim, and that was a tax measure, and it was found to be an expropriation. Now, I don't anticipate any of the EU member states or Canada behaving the way Russia did towards UCOS, but that's one example where you have had a direct tax regime condemned as being contrary to an investment agreement.
Professor O'Brien, thank you very much for your time today, and enjoy the conference.
Thank you very much, Marcel.